And
Yes.
since this session is YouTube live as well, it's the first session of the event. With your permission, I would like to start it.
Yes, please.
Good evening to all the attendees presented here. It gives me immense pleasure to introduce Ms. Medha Singh, an accomplished academician and expert in criminal law, as a guest speaker for our 5-day online course on cyber law and cybercrime organized by Legal Expatriate. Ms. Medha Singh is currently a lecturer at a School of Law, Forensic Justice and Policy Studies, National Forensic Science University, Gandhinagar, Gujarat, where she plays a vital role in educating the next generation of legal professionals. She completed her undergraduate studies at Amity Law School, Lucknow, and went on to pursue her postgraduate degree specializing in criminal law from Institute of Nirma University, where she honed her knowledge in criminal justice and allied disciplines. With over 4 years of teaching experience, Medha has developed a reputation of her insightful teaching and research. Her deep interest in criminal law and its allied fields has fueled her passion for understanding the nuances of modern day legal challenges, particularly in the domain of cybercrime. As part of this course, she will guide us through critical aspects of cyber law and crime, exploring its intricate overlap with criminal law. Her experience and academic rigor promise to provide a unique perspective of combating cyber offenses and understanding the evolving digital legal landscape. We are honored to have her with us and look forward to learning from her vast knowledge and expertise. Let us all welcome Ms. Medha Singh and look forward for engaging an insightful session. We hardly welcome you, ma'am. Over to you.
I hope I am clearly audible to everyone. Thank you so much for that very generous introduction. As has been already told, this is the first module, and I will go through with the entire presentation, and there is the brief outline of the presentation as well. I hope you all have a good learning experience, and let us begin. So, the outline of this session that I am supposed to be taking is basically giving you an overview of the Information Technology Act 2000. And from giving you a base of sorts, a basic understanding of how the IT Act in India works, we will move on to the provisions that relate to cybercrime in India with the perspective of all the new criminal laws. And by new criminal laws, I mean the new criminal law statutes, which are the BNS, BNSS, and BSA that have been enacted. So we will go into the intricate details of that as well. I would like to also inform you that please pay attention to the change in the numbers of the sections, because there are some cases cited here as well that are of the IPC and CRPC and evidence, so there could be a little bit of confusion. So I am giving you a disclaimer before I begin. So without further ado, let us start with the Information Technology Act. This is the most basic piece of information about it. It is one of the most important uh, cyber law related legislation in India. It has been enacted because of ratifying an international obligation, which is why we enacted Information Technology Act in 2000. It was enacted on 17th of May 2000, and it has 13 chapters, 2 schedules. I am not going through all of the chapters for obvious reasons that there is a paucity of time and I have to go through a lot of it, but I have sort of amalgamated the importance, the scope, and some important features of IT Act for the sake of better understanding. So this is the introduction. Uh, so why did we need something like the IT Act? So a lot of you already know the answer to this. For those of you who don't, it provides recognition to all kinds of transaction that is carried on by electronic data interchange, other means of electronic communication, which is also referred to as electronic commerce. So advent of technology is taking over all of our lives by a wave, and it was absolutely apparent that we incorporate or we start incorporating the use of technology in all the fronts of our life, even law. So IT Act, even though is currently, because we're in January 2025, is a 25-year-old legislation, but is still very, very ahead of its time. There are obviously loopholes and drawbacks in every legislation, so this one has as well. But nonetheless, it would be remiss to also point out the fact that this is a very well thought of, ahead of its time kind of legislation. So there were as you all can very well agree with, that we nowadays cannot imagine life without any kind of interjection, or rather interplay with technology. And because of that, we are so much of our lives are on the internet because of it. So even though IT Act began from the, or it has its root in electronic transactions rather than the cyber world, which includes the internet, I feel that it is important to make a distinction between these two, because a lot of the times people think that cyber laws and IT Act are sort of like the same thing. They are, IT Act is the bigger umbrella, is the bigger circle in the Venn diagram, and you'll find cyber laws within it, because electronic data and electronic data interchange, electronic communication ultimately is coming through a device. And now these devices have also introduced the internet. So these things are kind of overlapping, but please remember they're similar, they're not the same. So when we talk of the IT Act, that is why it is still a legislation that has drawbacks, that it is a remiss on the advent of internet within it. I will tell you more about it as we go ahead in the presentation, but I felt like it was important to maintain this distinction that cyber laws are an entirely different realm, whereas IT Act is like a door, which is, or rather a window, which makes us understand cyber laws. So that is why the first module is the IT Act. So point number two is to facilitate electronic filing of documents with the government. This is a pretty generic explanation, doesn't really need much to be explained per se. Number three is, due to increasing crime in cyberspace, this act was enacted to safeguard the interests of all internet users. Now, you will find out as you will read this act that that has not always been the case with IT Act, because when IT Act was enacted, the use of internet was not as prevalent as it is today. That is why we have had so many different rules come up over the period of time, and so many different amendments in the IT Act to incorporate the changes that time and technology has brought into us. But to give you an overview, IT Act was enacted to sort of regulate, supervise, and legally recognize, give authenticity to any kind of transaction which is done electronically or through electronic communication, and any kind of data exchange that is happening as well. Also, given I have shared my screen, I cannot actually look at the Zoom screen. So I cannot really interact at the moment, and also not answer questions. So that is reserved for the end of the session. So I hope that is clear to everyone. All right. Then there are, what is the scope of the IT Act? So it is obviously just like every other act in India, it is applicable to all the states except for J&K, but that has also changed after Article 370. I hope that everyone is aware about that. Every electronic information which is under the scope of IT Act 2000 comes under the purview of this statute, barring some of them. And what are the things that are barred? So number one is, if you attest the you test by creating a trust. So those things cannot be done electronically. It is not in the purview of the IT Act. If there is an attestation of a will of anybody, that cannot be done through that is not within the purview of the IT Act. Any kind of contract of sale of an immovable property and giving somebody the power of attorney. These transactions and these electronic information, even though these things can be communicated to one another through electronic means, they are not under the scope of IT Act under the term IT Act communication, or the electronic communication or data interchange. So these are some things that are barred from the purview of the IT Act. Now, these are some of the important features of IT Act. Now, it reads here as penalizes cyber crime. Now, as we go ahead, you will probably understand what are the things that it is really actually penalizing. Cyber crime, like I said, is a very big umbrella term. We at the moment do not have a lot of legislations in our country which are governing cybercrime per se. We have only IT Act which talks about it in great detail, but even then it is not very attuned to how the cyberspace works. So we're trying it. That is why there have been so many judgments and cases time and again that are changing the way that the judiciary has interpreted the IT Act. So it, yes, it penalizes cybercrime. I'll tell you what those punishments under IT Act are, and I will be able to be in a better position to explain them to you. Enhances corporate business. Now, as you all must be aware that we study law of contract in our first and second semester of law school. Every one of us here in law school been to law school, are in law school, have been out of law school, know this, that when if you have been introduced to something called as the knee contract. So if you are engaging in any kind of transaction through the internet, you are entering into a contract of sorts with the user interface of that website, which comes under the purview of an e-contract or a special kind of contract. Now, all those things weren't available earlier, right? Those things were not really an opportunity to in the sense of commerce or business available to people always. And IT Act has made it easier because it has regulated corporate business. It has enhanced business. Now, the reason you are able to do online shopping so easily and you're able to basically order anything from anywhere and have it delivered at your doorstep is because there are laws that regulate how all of these business transactions are done by just clicking a few buttons on your device. So IT Act has definitely enhanced corporate business as well. Uh, it defines electronic records under section 21T, which includes any data, image, record, or file sent through an electronic mode. Within this, I would like to point out section 2, subsection 1, subclause 2TA, which is any signature which is used to authenticate any electronic record that is in the form of a digital signature is called an electronic signature. Now, these things, these electronic signatures happen to be very, very important when we talk about cyber crime or any crime that happens within the cyberspace. So, one very important feature of IT Act is it defines what an electronic signature is and how it will be used and appropriated in different kinds of transactions, right? So, 21T and 21TA, both are very, very important features of the IT Act. Next is section 17, which is the appointment of a controller, and section 18, which isn't written here, but section 18 is the functions of the controller. Now, what exactly is the job of the controller? He supervises all the activities of a certifying authority, and all the public keys are also certified through the controller. Now, a controller is sort of like if I were to compare IT Act with the Air Act or the Water Act or the Environmental Protection Act that has a state government authority and a central government authority, which are a regulatory body of sorts, which are basically required to supervise every transaction and every kind of supervision that is required within the purview of this act. So it is similar in that reference, obviously. Next is license for electronic signatures. Like I said, electronic signatures are any signature that is used to authenticate any kind of electronic record, and who has the license for those electronic signatures is mentioned under section 21. Again, a very, very important section. One of the most important sections of IT Act is actually section 79, the one that we need to be more concerned about, the most concerned about if we speak strictly in reference to cybercrime. Now, before I go into what these words written on the screen mean, let me first bring you all to this one understanding that we're all putting out information, personal information, through one means or another into the world. And by into the world, I mean you fill up forms where you put in your number, you fill up online surveys where you put in your email addresses. Then there is so much of your personal data which is linked to your email IDs as well as your phone numbers, and through this we leave bits and pieces of our personal information on the internet. Right now, um, think of it this way, that you want to get something, but before you actually go to retrieve that thing, you have to sort of give a fees of sorts, or rather you have to pass a checkpoint. To pass that, you have to show some authenticity in the manner of your phone number, your address, your personal information, your name or your email address or something like that, for you to proceed to the next step. Now, this one important check in between, this person is, or this particular interface is asking you for personal information, not for themselves, but so that you can proceed to the next step. Now, this mediator, the one who is in between you and reaching this intended target, is what an intermediary is. Section 21W of IT Act defines an intermediary as an it doesn't say it's a person, it doesn't say it's a company, it doesn't say it's a thing. It says intermediary is who receives, transmits, stores information of people on behalf of someone else. Please pay attention. If you can, and if you have it, the IT Act at your disposal, you can open it, section 21W, which defines an intermediary. An intermediary is who receives, transmits, or stores data or information of people, bear in mind, of people, on behalf of someone else, and provides services like telecom, search engines, and internet services, online payment, etc. Most important thing here to remember is that an intermediary stores your information not for itself but for another person or for another source. An intermediary is what concerns us the most, in the sense that it is them who have all of our data. So if you are getting a lot of messages from different factory outlets or different stores and different malls and different places that you've never really visited, or if you're getting calls from multiple banks that you have never visited, you've never had an account with, and you're getting emails, all of this is happening because there is one mediator, an intermediary in between, who has taken up all of this data, has disseminated your data for multiple purposes. So that is the reason you as a consumer, you as somebody who is the end customer, is being subjected to all of this, because your data without your permission has been now, without your permission comes with an asterisk. I understand that without your permission is a privacy concern, but let me tell you this. There is a lot of fine print written when any kind of website is asking you to put in your personal information. For example, let us say there is this website by the name of Quint, which publishes news. It's a it's a website that reports news of various kinds. Now, I've been reading articles on Quint for, let's say, 6 months, and they are allowing me to read it for free. But after 6 months have passed, they have realized that this one specific IP address has been logging into this website too much, and we need to restrict access. So, and they are somebody who are regularly visiting the website. So they will ask you that the free trial of looking at all of these articles have expired. Please sign in. Now, signing in doesn't really require your money, right? So you think it doesn't really matter. You just put in your email address, you use your you use your Google account, log in from Gmail, and you go ahead and you start to read this article. Now, this website is functioning because a lot of sponsors have given it money for it to run on the internet. So, on the sides, on both of the parallel sides of this article, you will find plenty of different ads, from Make My Trip to Go Ibibo to Agoda and God knows what not. And suddenly, one day, you go to your Gmail, and on the promotions, you will find that Skyscanner is sending you emails, and that Agoda is sending you emails, or Make My Trip is sending you emails. Is this AI listening through your phone? Yes, of course. Yes, it is. But it is also because you put in your information on Quint, that is also able to function, because your data, it used your data as an intermediary and it disseminated it to God knows where. So when you are putting in your information, there is always a disclaimer that seldom people read, a disclaimer that people most definitely avoid, because as long as your money is not spent, you are not really concerned of what is really happening, right? And then suddenly it becomes a whole problem of getting spam emails, because this, I'm giving you an example which is a rather safe example, but there, if you are, any one of you actually, if you go ahead and you check your spam folder on Gmail, you will find a tremendous amount of gunk over there which has come from god knows where, no matter where it is that you have clicked, but this thing has accumulated in your email. Now, I hope we're all on the same page as to who an intermediary is, somebody who stores data for somebody else. Now, usually when the data is stored by intermediaries, it is misused. That is why I was giving you this examples that for obvious reasons, it is definitely misused. Why else would you store somebody's data if you're not going to use it? Now, I'm not saying this use is always obviously bad use or misuse, quote unquote. It could very easily be construed that it is not used for a legitimate purpose, given that you are not being asked permission for it. So, Section 79 gives us an exception that earlier anybody who was storing data before the advent of IT Act, actually, sorry, um, any intermediary that was storing data was actually liable if the data is misused. But Section 79 has made intermediaries not liable, they are not held liable. What are the exceptions? I will tell you. If you have the IT Act with you, please read Section 79. Third party information or communication. If there is any kind of information which is not pertaining to the intermediary themselves, but it is between the end customer and the intended website that they are using, then they will not be held liable because they are only holding the information for somebody else, basically giving teeth, giving importance to the whole concept of what an intermediary is supposed to do, holding information for somebody else. If the role of an intermediary was to only provide access, now, let's say that you book a flight. You book the flight from an airline by the name of Indigo. Now, you are, let's say, person A. Your flight is of the company Indigo, but you booked this flight from MMT, MakeMyTrip.com. MMT here has your data, and MMT here is the intermediary because it has used your data to give it to Indigo, and you have used MMT to track information of Indigo. So that way, MMT becomes an intermediary. They are only giving access to the third party. So, because if their role as an intermediary is to only provide access, they cannot be held liable. And if Indigo goes ahead and uses your data and is misusing your data, Indigo must be held liable, not the intermediary MMT. Lastly, if the intermediary did not initiate any kind of transaction. Now, if you are an intermediary and by the virtue of you being an intermediary, your job is to hold information for somebody else. If you are going away from the purview of your work and disseminating the data for some other purposes or giving it for some kind of illicit activity, like you start to get spam calls or you are getting emails that are installing any kind of virus, you must be aware that there are emails that you get which are flashing very, very scandalous title. You click on it and immediately a spyware is installed on your computer. You don't even realize that has happened. So if intermediaries are in that kind of business and you are not, and they are actually initiating that transaction, only then will they be held liable. Otherwise, if they have not really initiated a transaction, they will not be held liable. So these are some important features of the IT Act. I hope up until this point it has been clear. I would like to now discuss some of the important, one more section I will actually like to tell you before I go ahead with offences and their punishment under the IT Act is section 43, which talks about what exactly, I think it must be mentioned in this as well if I'm not wrong. Just give me one second. Not, it mentions from 65 to 67. Okay. Nonetheless, section 43 talks about what exactly is the electronic record which you are which is subjected to any kind of misuse. So if you download or make copies of any information which is stored in a system, what exactly qualifies as an offense per se, right? So if you download or make copies of any information stored in the system, you introduce any virus to the computer and you disrupt the computer system, You deny access to the owner or the person who's authorized to use that computer. You tamper or manipulate with the system, destroy or delete and make alteration and steal the information. So these are the things that basically are the offenses really that IT Act really talks about. This is mentioned under Section 43. You can go ahead and read it. Let us go ahead and now read the offenses and their punishment under the Information Technology Act. Please bear in mind that the section as well as the punishment, we will try to discuss if these punishments are actually adequate punishment, if this is what the IT Act must continue with. So first is section 65, which is tampering with the documents stored in a computer system. So imprisonment of 3 years or a fine of rupees 2 lakhs or both. Tampering with documents that are stored in a computer system. There have been cases that have dealt with in detail that what exactly constitutes a computer system. So does your phone constitute a computer system? In a way, yes. Does a computer system mean that it has to have a desktop? So I'm just going about any kind of confusion that might come into your mind reading these. As you can see, offenses related to computers or any other act mentioned in section 43, which I was telling you about right now. So, which is section 66, imprisonment of 3 years or a fine that extends to rupees 5 lakhs or both. Receiving a stolen computer source or device dishonestly, that is section 66B. As you can see that the imprisonment in all of these that are mentioned are imprisonment of 3 years, and the fine is ranging from 1 lakh to 2 lakh rupees. That is it. Then next is identity theft. Identity theft and identity fraud are also available in BNS. They are, and so bear in mind that IT Act is a specialized legislation, and IPC, or right now as it is BNS, it is a centralized legislation. So whenever there is a conflict between a special legislation and a central legislation, the special legislation will take precedence. So identity theft and identity fraud is also mentioned in BNS. Imprisonment of 3 years or a fine of rupees 1 lakh or both. Cheating by personation, either an imprisonment for 3 lakhs or fine of rupees 1 lakh or both. A violation of privacy, either imprisonment up to 3 years or a fine of rupees 2 lakhs or both. And next is cyber terrorism. Now, cyber terrorism is a very, very wide definition and hasn't really been deployed as of yet, but it is clearly mentioned here that cyber terrorism as an offense under the IT Act is clearly mentioned. Next is transmitting obscene material in electronic form, imprisonment of 5 years. These are a little more heinous offenses. So, transmitting obscene material in electronic form, imprisonment of 5 years and a fine of rupees 10 lakh. Now, transmission of any material containing sexually explicit acts through an electronic mode, 67A, 7 years imprisonment and 10 lakh rupees fine. Depicting children in sexually explicit form and transmitting it is 67B, imprisonment of 7 years and a fine of rupees 10 lakh, and a failure to preserve and retain the information by intermediaries, again imprisonment of 3 years and a fine which is not really mentioned. Now, I would like to point out that cyber terrorism, as well as all the offenses mentioned under 67AB, uh, 67 and 67AB are related to any kind of uh, illicit activity that happens over the internet. So 67B is talking about child pornography, to be precise, and 67 and 67A is talking about exchanging any kind of sexually explicit content through the internet. So these sections aren't really talking about consent per se. You will that these sections are silent about consent.
Participants, we are coordinating with the speaker. Please have patience. She'll be right back.
Ma'am, you can unmute yourself. There is some technical glitch from a speaker side. She is rejoining in 2 minutes. Ma'am, could you please unmute yourself?
I have unmuted myself. Am I audible?
Yes, ma'am, you're audible.
Okay, I need somebody to please let me know where have I left off so that I can continue from there. I'm so sorry I was not able to see the screen, so I didn't know that this had stopped. Can one of you let me know in the chat so I can continue from there? 67C, okay. 67B, okay, no worries. All right. Okay, so I was just letting everybody know that section
Ma'am,
67
your voice.
and 67A are sections that are talking about transmitting. Am I audible?
Mm, yes, but in between your voice was getting echo, so it was breaking. But I guess you can speak for like 5 minutes. I'll give you a confirmation check.
Okay. I'll continue to speak. Like I said, I cannot
Yeah, yeah.
really view the Zoom screen at the moment. So if you could please interrupt in between and let me know, that'd be great.
Yes,
Um, I
sure.
was talking. I was talking about this case called Emmett George versus State of Maharashtra. It's a really old case, and it talks about the difference between explicit mens rea and implicit mens rea. So, irrespective of the fact that none of these sections really mention mens rea per se, and it doesn't factor in consent of the person that you are in this transaction of sorts, it includes implicit mens rea. So if there is any kind of transmission of sexually explicit content through over the internet, it will be assumed that it is done because of this intention to commit an offense, right? So if any one of you are interested, please go and read about the distinction between explicit mens rea and implicit mens rea. There are a lot of sanctions that are, you will view them very construed from how
Ma'am, can you hear me? Yes, video has been paused again.
Ma'am, you can unmute yourself.
Am I audible?
Yes, ma'am, you're audible and visible.
All right. My sincerest apologies. I am on a bad internet here. Just give me 1 second.
Ma'am, it would be better if you turn off your camera and display the screen. I think participants will be okay with that also, and it will give a less disruption.
1 second. Is the screen visible?
Yes, ma'am, it is visible.
Okay. All right. I was talking about this case, MH George versus State of Maharashtra. It's a very, very old case that discusses the difference between explicit mens rea and implicit mens rea. When provisions have the words dishonestly, fraudulently, knowingly, intentionally written in them, they are considered as sections that have used explicitly written in the statute that there is mens rea, that there was intention to commit some kind of offense. But there are some sections, actually a lot of sections that you will find that don't have these words written, but they are nonetheless are talking about uh, in intention of the person who is making that offense or who is committing that offense nonetheless. So the case is MH George versus State of Maharashtra, and this case is authored, if I'm not incorrect, by Justice Bhagwati. Anywho, I wanted to discuss these two amendments which are written over here, which is the amendment of 2008, which was brought to us by, is it just me or is something been drawn on the screen? Okay. Nonetheless. The Shreya Singhal versus Union of India happens to be one of the most landmark judgments that IT Act has to offer. It is a very, very important case. So this was a very controversial section as it is provided punishment for sending any offensive messages through an electronic mode. Any message or information that has created any kind of hatred or hampered with the integrity and security of the country is now prohibited. However, it did not define the word offensive and what constitutes the message, which was what most people, which a lot of people were arrested on this ground. And this section was a little problematic as well. Ultimately, the section was struck down by the Supreme Court in Shreya Singhal versus Union of India. Another amendment that was made is in Section 69A, which empowered the government to block internet websites for national security and integrity. You must have heard about this app called as TikTok, which was banned because people were saying that people is a wrong word, because the government was of the opinion that all of our data is being shared into another country, and that is why TikTok was banned. So it is because that the government can decide that because of the threat to national security and integrity, it can block internet websites. The authorities or intermediaries could monitor or decrypt their personal information stored with them, and that is why it is absolutely necessary that government holds this power within them. Now, if you remember, I was talking about the controller and what are the powers of the controller. Some of them are very, very similar to what is mentioned under 69A. Next is the 2015 Amendment Bill, which is initiated to make the Act more in line with the constitutional guarantee of fundamental rights. And this bill made an attempt to make changes to Section 66A, which provides the punishment for sending offensive messages through electronic means. What it's basically talking about, as you can see very easily, Article 19 is also written. So I was just discussing this with a colleague of mine today, that you must be aware of, if you are interested in any kind of news or world news that is happening, that in the US, president has taken office, and it is President Trump. And while he was being officiated as the president, and when he was taking oath, there was this bishop who was conducting this ceremony. And this bishop, this person, this lady, she looked straight in the eye of this president-elect, Donald Trump, and she said that I take it upon myself to say that when you are going to be making laws ahead in this reign of yours, in this tenure of yours, please bear in mind of the LGBT, of all the immigrants and all. And she said some very, very harsh things, some would say, or rather some truth that needed to be told. So something like this would not float in India. You cannot possibly imagine that the president, like anybody who is in power in the government, and a lot of power in the government in our country, and somebody speaking against them directly. And the answer to that one thing is the fact that we do not have absolute freedom of speech and expression, which the US has. So you can realize why the Section 66A and the 2015 Amendment Bill are sort of on the same lines, because Section 66A is restricting your freedom of speech and expression. And if you can see here, it is written, provides punishment for sending offensive messages through electronic means. It's talking about a Twitter era, Twitter, which is now X. It's talking about the time where there was a lot of voice on the internet in the form of tweets, and they weren't really regulated per se. Then the section was amended, and then there came the Shreya Singhal judgment, and anything quote unquote considered to be offensive and threatening the national integrity and security of the country came under the purview of the government of India. So this section did not define what amounts to offensive messages and what acts would constitute the offense. It, however, further struck down by the Supreme Court in the case of Shreya Singhal, declaring that it is violative of Article 19. So you realize why these amendments were required, right? Anyway, moving forward, these are some landmark judgments. When I will share with you this PPT, I will also be sharing another document as well. That document will contain these cases in detail, as well as why is it important to read these cases on IT Act as well. I'm not going into detail about these because I want to discuss the more important parts of this lecture, which is BNS, BNSS, and BSL. What are the loopholes and drawbacks of IT Act? Now, there is no provision for breach of data. There is no provision for breach of data. That is, there is absolutely no provision for breach of data, because like I just said, that Section 79 does not criminalize intermediaries, and intermediaries are the ones who are holding the most of our data. They are the one disseminating data to you as an end customer. Your data is at risk, and there is a very clear breach of data. IT Act and its interplay with right to privacy is something which is of very important concern and very important discussion these days. One more important thing I would like to mention is the PDPT, if I'm not PDPT, Personal Data Protection Act, PDPA, I think, if I'm not wrong, also discusses a lot about these things. This act is IT Act is a little silent on breach because there is a special legislation which specifically talks about protection of personal data, right? So the provision for breach is per se not mentioned in IT Act, but you can obviously go to another specialized legislation. That being said, Privacy as a concern will always be overridden by the state's interest, something that I want every one of you to take away from this lecture, even though that is not the intention of this lecture. But one thing that I want every one of you to always remember is that any kind of citizenry related concern will always be overridden by the state's compelling interest. Always. The state will, one way or another, have a overarching power in the form of national security and integrity of the state. So, and when I say state, I mean the government of India. So you will find that this is the one thing, these couple of words, these phrases in sections, which gives government to power to regulate literally everything there is. That is why if you read, like after having been told this to you, if you go ahead and you read any other legislation, you go and you read the Constitution of India, you will find that even if you read right to life and personal liberty, unless procedure established by law, that is very clearly mentioned, that even if you will be deprived of your life, it will be through a procedure established by law, because the state will ultimately decide what is happening and it will decide the state of affairs. That being said, if the state is of the opinion that anything, quote unquote, disturbs, harms, threatens the international peace and security, the national integrity and security of the country, it will strike it down. This is a very important phrase that has come from plenty plethora of chronological cases, starting from MP Sharma, Satish Chandra, Kati Kalu Ogar, P. Ratinam. There are multiple cases that discuss this. Irrespective of what kind of subject matter you are talking about, whether you talk about evidence law, whether you talk about right to life and right to die, irrespective of what you are talking about, irrespective of what legislation, compelling state interest. Bear in mind, take this away from this lecture. Okay, no address to privacy issues. Like I said, that we have time and again enacted multiple personal data protection bills. Now we have a Personal Data Protection Act as well. That is why IT Act is not specifically talking about privacy issues. Also, the biggest loophole is not criminalizing the role of intermediaries. That is also a very big red flag in IT Act, but it is being addressed by other specialized legislations as well. Lack of trained officers. I would like to tell you that there is, yes, there is a lack of trained officers, but institutes like mine that I am associated with, very, very thankful to that. I can tell you that this lack is changing. And as people of this country, you must also know how that is happening. So the ministry has put in a lot of, Ministry of Home Affairs has put in a lot of effort in organizing training workshops for government officials, for scientific officers, for police personnel. And institutes like mine, which is an institution of national importance, we are not just doing the academics in one vertical, it is also training and consultancy. So that is changing, but that change is not going to be visible to, or rather known to people very, very soon. It's going to take a lot of time to be able to see considerable change in the terms of trained officials. It is happening, of course it is. That is why the government enacted the new 3 laws, which is making way to change the way our entire justice system works. It's going to take a while, but yes, do we have lack of trained officers that are unaware, that are oblivious to how these things work? Yes, they are. There are simple punishments, relatively simple punishments, because like I said, things that happen in the cyberspace realm are very, very difficult and very different to comprehend. So an IT Act is of 2000. So yes, of course, it lacks some creative punishment, because more often than not, it is difficult to even apprehend the person committing a cyber offense per se. Next is no regulation over cyber crimes, like I told you. Think of this in this way, that we also we have a lot of laws that regulate frauds. So if you talk about any kind of scam or fraud, there are plenty of laws. If you go and you read these laws, you will find that none of these laws are preventative. Preventative in the sense that they are not going to prevent a fraud from happening. They will only tell you the remedy after the fraud has happened. What is the point of a law if it is not preventing an offense? That, I think, is the biggest drawback of a legislation. that if it cannot prevent a wrong or an omission from happening, all it is doing at the moment is just telling you what the remedy is, which I think happens to be the biggest lack. If you read over any kind of fraud, money laundering act, or any kind of fraud related case laws, you will find that after the fact, the law has sort of intervened, but not before, and definitely not during, because you are not, how do I put this? You're not made aware of something like this happening until after it has happened. So I think that is the biggest lack of IT Act and a lot of other specialized legislations, is that they're not preventative in nature. They are remedial in nature, obviously, because that is the job of the law, to remedy the wrong. But more often than not, I think if you speak in terms of the criminal justice system and crime per se, laws need to be preventative. Anyway, let us now move forward to provisions of cyber crime in India. Just give me 1 second. All right. So there are multiple provisions in BNS. I would like to give you a disclaimer very much in the beginning, that most of these cyber crime provisions are only present in the BNS, because BNS is a statutory law. BNS is a law that has definitions that define what act and what omission constitutes an offense. BNSS only discusses procedure, and as far as cyber crime is concerned, it only talks about the introduction or the advent of technology in the investigative stage. So there is not really any provision in the BNSS, which is the new CRPC. I am telling you this because no matter where it is that you start to read this from, if you try to Google it or you try to find it on ChatGPT or any kind of AI tool, you will not find a provision relating to a cyber crime in BNSS, because bear in mind, it is a procedural law. It talks about how technology can be used in investigation. So the most important thing for us in all the three laws is maybe a little bit of BSA and majorly BNS, not BNSS. Nonetheless, as I've already shared this PPT with the moderators, I will also share 2 more documents which have a little bit more about it. Due to the paucity of time, I will not be able to discuss all of it in this lecture. Nonetheless, let's move forward. Distribution, sale, or offering for sale of hardware, software, or other tools used to commit cyber crime is strictly prohibited under Indian law. This is a very generic statement. IT Act, especially Section 67C, mandates intermediaries to preserve and retain information in a manner and format prescribed by the central government, and non-compliance could lead to imprisonment. I have already told you what non-compliance does. Section 69 of the IT Act, it grants government the authority to interpret, monitor, or decrypt any kind of information that is generated, transmitted, received, or stored. And if it is necessary for the interests of sovereignty and integrity of India, defense of India, security of the state, or any other reason. Section 69 gives a lot of power in the hands of the government to appropriate that data, if I may use this word for the lack of a better one. Therefore, selling or distributing cyber crime tools can be seen as abetting cyber crime. Now, what exactly are cyber crime tools? Are these actually tools you can find in a shop? No, of course they're not. These are softwares. These are things that are hidden within lines and lines and lines of code that is not discoverable, that is not visible by any of us who are not aware of how these things work. Having to retrieve this, having to disseminate it is an offense. That is the cyber crime. Leads to severe penalties under the IT Act, okay, including imprisonment 7 years. We already know this. BNS complements these provisions, and by including offenses such as conspiracy and abetment of crime. One of the best things that I find about BNS is that in one way or another, it will make space for different kinds of things that are happening in the realm of crime. So even though you will not find the words of cyber crime per se, but abetment of an offense and conspiracy to commit an offense will always find its way back to the central legislation, which is why I think it was a very beautifully written legislation before IPC became BNS. It still is, because it has retained most of it. But I think it is important to give credit where it's due. People that have actually written our laws, at least our archaic legislations, were thinking way ahead in time, and that kind of foresight is, frankly speaking, not present in any of us really. Anyway, I'm digressing. BNS complements these provisions by including offenses such as conspiracy and abetment of crimes. I will tell you what those offenses are, which would cover the sale and distribution of the cybercrime tools and etc. etc. This is just to give you an overview that BNS also has a lot of provisions that discusses that has an overlap with the IT Act. Identity theft or identity fraud, it is in connection with the access devices. Identity theft involves that you are impersonating another individual by obtaining their or fraudulent, like you see this line written here, impersonating another individual by obtaining and fraudulently using their personal information. Now, these lines are very clearly indicative of the use of mens rea, because it uses the word fraudulently using their personal information to cause any kind of financial or reputational loss. Let me give you an example. If you lose your debit card today and you find out that there are multiple transactions that are happening in an ATM trying to withdraw money, that is identity theft, because whoever is using that is obviously not you. And if, let us say, somebody gets a hold of your phone, your unlocked phone, it doesn't really happen much, but if somebody gets hold of your unlocked phone and they have access to your passwords and they make some internet transactions of money, or they are communicating with somebody, they are making any kind of promises or any kind of fraudulent transactions, if they are doing it, representing it as yourself, that is identity theft, that is identity fraud. It can be through phishing scams or fraud calls, etc. This is an offense which is under IT Act as well as the IPC. Like I said, please bear in mind it could have IPC and BNS both. Relevant sections include Section 66C, which punishes identity theft by using another person's identity information fraudulently. Imprisonment is for 3 years and fine is up to 1 lakh. 66D is punishment if you are using a computer resource within the same penalties. Making a fake ID on a social media account, impersonating somebody and then causing them some kind of harm, financial or reputational, is also an offense. I would like to inform everybody here that more often than not, it has crossed our minds to do it, to make a fake account to torture somebody. Do not do that. It is an offense. We think that we're being smart, but the law is smarter. That is why we're all in this field trying to understand what is written and what can be construed out of it. Anyway, important thing here to remember is also that if this information is used for financial or reputational loss. So bear in mind that both of those things are mentioned here. Now, this is a case, this is a fairly recent case of Cognizant Technology versus AM Shah and others. Employees of Cognizant were found guilty of identity theft because they were using stolen credentials and accessing confidential data. Legal provisions were 66C of the IT Act for the punishment of identity theft, 66D for cheating and impersonating using a computer resource, 419 and 420, which are the sections of cheating in erstwhile IPC, BNS. I don't know the corresponding section, you can check. The court upheld the conviction of the employees, reinforcing the legal framework against identity theft and the misuse of personal information, another very important case. Any other activity that adversely affects or threatens the security, confidentiality, integrity, or availability of any IT system, infrastructure, communication network, device, or data. These words weren't always present. You will see that all of these sections have a letter attached to it, which mean that they have been inserted through an amendment, right? Section 66F of the IT Act talks of cyber terrorism. I was telling you earlier, it is defined by any act to, I don't think I really need to explain to you what terrorism is because it has the word terror in it. So any act to intend to threaten, what are you really threatening? Unity, integrity, security, sovereignty of India, strike terror in the people. How will you actually do that? Denying or causing to denial access to any kind of computer resource to that person or the authorized person, attempting to penetrate or access a computer resource without authorization, introducing or causing the introduction of any computer contaminant. The punishment is obviously the imprisonment for life. We've not really had a case of cyber terrorism in India. God willing, touch wood doesn't happen also. But I'm sure you must have seen it in popular media representations that a group of hackers, they hack into the main computer frames that runs everything. So traffic lights and all kinds of things that are run on electricity. So they have penetrated the mainframe and they are now asking for ransom. If anyone here is a comic book nerd and has seen or has read Age of Ultron, Avengers Age of Ultron, Ultron is a virus of sorts, which is a very good example of how internet can be used, information can be used to create a threat and terrorize people on the basis of information. Also, something that I need you to take away from this lecture is that any kind of information, be it words you're putting it on the internet, pictures you're putting on the internet, pictures which are of a sexual nature that you are exchanging, pictures or messages that you are exchanging that may or may not be PG-13 rated. All of this is currency on the internet because somewhere someone wants this data. So bear in mind when you are on the internet next time, so that you are more mindful of what you are putting out there. Because something that also I was discussing with one of my friends is that people now are being remembered by what they put on the internet, because internet lives forever and so does the space and the information that you leave out there. So it is always going to be there, so please be very mindful of that. Anyway, section 121 of IPC, which is now section 147 of BNSS, consists of waging war and attempting to wage war. Now all of this can be done through the internet, so that is why this section is mentioned here. This is against the government of India. Obviously, it is punished by death or imprisonment for life, can also be liable for a fine. 124A of C, which is 152 of BNS, is sedition, something which was also very prevalently done through Twitter, if you all are aware. I do not really need to explain that to you. It is also something which is a cyber crime of sorts. Certain offenses under the IT Act which have extraterritorial application, meaning they can be applied to the acts that are committed outside India as well. So Section 75 of the IT Act is one of those, which is that the provisions of IT Act will apply to any offense or contravention which is committed outside of India that involves a computer, a computer system, a network located in India. So if you are doing something which is punishable in India, it will very necessarily be punishable outside as well. Section 3 of IPC, which is now Section 1, subsection 4 of BNL,
I'm so sorry. Actually, there is some technical glitch from the side of speaker. We are helpless. Ma'am, you're visible now.
Is the screen visible?
Oh, yes, ma'am, it is visible. Also, there are a lot of questions in the chat box regarding the PPT and stuff. Please focus on the session. We'll provide all the things.
I'm sorry, I'm not able to see them anyway. So, if there are any things related to that, please let me know later on. Let me just go through with this because of really it is lagging so much. Without further ado, let me just finish this off very soon. There were some more sections that I wanted to discuss, which is just give me 1 second. I want to close the chat box. Yes, which is section 294 of BNS, which addresses the publication, transmission of obscene material, including electronically. One thing that I want to let you know, because everything you will have it in text form as well, is that the most important change in BNS, BNSS, and BSA is the fact that they have added electronic means to existing uh, electronic
Ma'am,
means
sorry to
electronically,
interrupt.
electronic means everywhere. So all of
Ma'am, can
this
you hear me?
is sort of already.
Hello.
Yes,
Ma'am, I would request if you
yes,
could turn
yes.
on the video, because I guess the
Yes, you're
voice is
audible. Am I
little.
audible?
You're audible. What I'm suggesting is that we can take
My
off the
video is
video.
turned on. My
No, no. I
Okay,
am
okay.
suggesting, yeah, so that we will not have much connection.
Is that all right now?
Yes, ma'am. Please go with the flow. If in case it interrupt, I will let you know.
All right. My sincerest apologies for the internet lag. I'm at the office so that I did not have problems with the internet.